is well within the limitation period insofar as the obtaining the leave of the company court before institution of proceedings against the guarantor is concerned. That law is now well settled that only in case of the assets of the company being the part of the proceedings under section 31(1)(a), or if there is any connection to the company court's winding up proceedings, then we may have to approach this honorable court and seek leave of the company court before institution of proceedings under section 31(1)(a), or even the section 138 of Negotiable Instruments Act and under any other laws.
We don't have other assets, the other guarantors.
We couldn't find any other assets of the other guarantors. In respect of this guarantor is concerned, the conduct of this guarantor is not unblemished. There is an order of attachment in a proceedings before the trial court, the very same property. In 2011, the appellant executes an agreement of sale in favor of third party in respect of the attached property, and they did not execute the sale deed. The agreement holder instituted a suit for specific performance. That suit came to be decreed, and against which the appellant filed RFA before this honorable court. That RFA was allowed, and the judgment of the trial court has been reversed. The agreement holder approached the Honorable Supreme Court, and the order of judgment of the division bench has been confirmed. Before the Honorable Division Bench, there was an interim order granted directing the appellant to deposit 4 crores. She has deposited in the RFA, subject to result of the appeal. Of course, the appellant has succeeded in that appeal.
On the ground on which I have succeeded, my lord, there.
But what happened to that money?
That money, in all probability, they would have taken back from this honorable court because they succeeded in the appeal.
It's gone.
Another aspect is that in 2021, the very appellant submits a representation to the first respondent, seeking consideration of a request under OTS, under one-time settlement scheme. After all these things, they cannot raise these technical grounds to get away with the liability of 22 crores. And the property now worth, according to my instructions, it is more than 12 crores. They have to deposit some, that is lordship's discretion. In effect, when an appeal is filed, it is mandatory that entire money should be deposited. However, it is the discretion of the appellate court to impose such other conditions as this honorable court deems fit.
You have not initiated any execution.
As of now, my instructions are that the execution petition is not yet filed because the appeal is filed. The interim order cannot be without his.
If I may just clarify.
Yes, my lord.
You see, you have to see, we are in a money decree.
No, my lord, so far as this money. No, my lord, what my learned friend is saying is that 4 crores has something, my lord, which I have borrowed, and pursuant to the final order of the court, that money went back to my agreement holder. I had to repay it with interest. That has been done.
That's all right. But tell us, was there any stay when the agreement was executed?
No, there was no stay. There was no.
Was there any attachment?
Yes, annexure. I have filed my
what
counter.
Is being contended is
Agreement of sale.
They could not have parted with this property when it is.
There is no parting, my lord, is my submission.
It's
a loan
yes,
agreement.
Mr. Nagaland, you have to tell us. Tell us.
My lord, I am in a difficult situation, my lord. I am not in a position. It's not as though the case IDC has no other remedy. They have remedies, my lord. Ultimately, my lord, if in case I succeed in this appeal,
we will look into it. Everything. Your plea of limitation, your plea of,
prima facie case, my lord, your lordship will see, my lord. Prima facie, my lord.
Right. Prima facie, yes.
Lord,
We will still look into it. Okay, we say nothing then.
Added to that, daughters have filed a suit for partition in respect of the same property. Daughters have instituted a suit for partition. We contested that suit. Suit came to be dismissed. From the year